Good morning. Early on a Friday. That's a great way to start. I'm Lauren Fisher Flores, and I'm excited to be here today with my colleague Alexa from GURP. We wanted to talk to you about T visas, particularly with the goal of encouraging advocates to file T visas, to provide you all some of the tools to start doing that if you're not already, and to really encourage everyone to think outside of the box on these cases and to use those zealous advocacy skills that we apply to all of this work in this particular area of immigration law. So at its very base, which is where I want to start, is what is human trafficking? And backing up just a moment, we're going to have three sections of our presentation. We're going to go through some of the basics of what is a T visa and what is human trafficking. Then I'm going to talk about labor trafficking cases, how to identify those and some of the common trends. And then Alexa's going to take over and talk about pushing the box and zealous advocacy and some of the amazing work that she's been doing. So back to what is human trafficking. This is not a legal definition. This is my way of approaching these cases and thinking about what is trafficking in order to start screening, to sort of ground yourself in what is really a very difficult concept. Trafficking is a legal term of art. It's not something that, you know, we just can pull from what we're seeing on TV or in the media. It's definitely about something broader, which is the exploitation of a person's body for another person's gain. The things you're looking for when you're screening for trafficking are a difference in power. You're often going to see an aspect of money and equity, some form of work, and then you're often going to see this inability to leave that keeps coming up. Human trafficking is broken into two broad groups of labor trafficking and sex trafficking. We're going to be concentrating on labor trafficking today. The legal definition within labor trafficking includes the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services. And then you look to the means, which are through the use of force, fraud, or coercion. And the ends, which is the purpose of subjection to involuntary servitude, peonage, debt bondage, or slavery. Sex trafficking, and I want to focus in here on what this means for working with child clients, is particularly about being induced to perform a commercial act for anyone under the age of 18. And commercial sex act is defined as any sex act on account of anything of value given to or received by any person. So it's a less demanding form than the force, fraud, or coercion that's required of adults. All of the words within these definitions have their own definitions, and I tend to look at the hhs.gov OTIP fact sheet for these. The link is embedded in your slide here. I want to focus in on the first two categories here of action and means. The first, the action, when you think about child clients, you want to particularly look towards what vulnerabilities kids tend towards. So this recruiting, harboring, transporting, providing, each of those defined here within the meaning for a child includes proactive targeting of vulnerability and grooming behaviors. Being a child is already a vulnerability. And so I would encourage you to think about the particular things within recruiting that are specific to child clients. Same goes for isolation, confinement, and monitoring of harboring. When you're working with children, often it's the adult that's supposed to be their caretaker that is doing this harboring, and the same would apply to transporting. Within force, fraud, and coercion, again, I would encourage the same sort of broad thinking that you use when determining whether a child is asylum eligible or what abuse and neglect standards look like for a child. When you think about what force, fraud, and coercion mean to a child. Force is something that I think we're more accustomed to working with. But the fraud and coercion branches here are really important to these cases, particularly in labor trafficking. Fraud includes false promises regarding employment, wages, working conditions, love, marriage, or a better life. And over time, there may be unexpected changes in work conditions, compensation or debt agreements, or nature of a relationship. When you think about this in terms of the sponsor relationship in particular, that's where you get into what does it mean for our clients? What do they expect when they're coming to the United States? And what is the reality once they arrive in their sponsor's home? Again, with coercion, what it looks like to find coercion when it's a relationship between a child and an adult. Particularly in these psychological manipulation. Maybe document confiscation could be something that an adult would normally do to hold a child's documents, but it can also change the power dynamic, and it can also change the child's ability to interact with the other adults around them, like their attorney. Shame and fear-inducing threats to share information or pictures with others. This is really big for kids in social media in particular. The way that someone who's trying to exert control over them can threaten to share pictures or share information about them, and the ways that teens internalize that. All right. Trafficking can occur anywhere. A child can be trafficked in their home country. They can be working in an abusive labor environment in their home country. They can be sex trafficked in their home country. They can be trafficked on the journey. They can be trafficked across the border. They can be trafficked in the United States. All of that is trafficking. So the place to start is my client a survivor of human trafficking anywhere? And if they're a survivor of human trafficking anywhere, then you want to look to see whether they already have an OTIPS benefits eligibility letter. If they don't, that's something that you can help them apply for, or if you have social services within your office, they can help them apply. You also want to back up and figure out whether that trafficking in home country might be a basis for asylum. Under the grounds of former trafficking victim type PSGs. And finally, you want to look at whether it's going to be the basis for a T visa. Not all trafficking is going to be the basis for a T visa. There are additional requirements for a child to be able to apply for a T visa. But definitely trafficking is the first one. So first, you want to determine if your client was a victim of a severe form of trafficking. And then you look to these next three prongs of whether they were physically present in the US on account of that trafficking, whether they complied with an investigation, and whether there would be extreme hardship if they were removed from the United States. And we're going to cover each of those grounds in the presentation. Some of them I'm going to cover, and Alexa's going to cover the others. So these OTIP eligibility letters, it took me the longest time to figure out why it was that I would get clients with OTIP eligibility letters, and I would screen them and I'd be like, well, this isn't going to qualify them for a T visa. That's because your OTIP eligibility letter is not about qualifying for a T visa. It's about working with a kid who has survived trafficking at some point, somewhere, anywhere. Even though it's coming from the US government, this eligibility letter is not about trafficking in the United States necessarily. So when you see one of these letters as part of your client's file, that should definitely cue you to ask more questions, but it's not necessarily going to mean that your client is headed for a T visa. Regardless, it is a really great resource to your clients. These letters, which can be requested by the shelter, by case manager, attorney, school counselor, anyone, they provide access to benefits that a client normally wouldn't be eligible for until they become a legal permanent resident. Those benefits include case management, rental assistance, a non-working Social Security number, Medicaid, access to counseling. There's some really great things. I put a sample up, actually it's from another sister agency here in Houston that I found online. And this eligibility letter, you wanna immediately look for the eligibility date. And then you want to understand or help your client understand rather that once they start, if they haven't already triggered their benefits, those benefits, most of them are good for 6 months. So they may want to consider the timing and talk to a case manager of, when it is that they most need those benefits. For example, if you have a child who's in ORR care or in CPS care, maybe they don't want to start receiving case management benefits until they're at their final destination. All right, so I've included a lot of slides here that are just for your reference, so that you have, for example, the reference to the INA here, and you can not have to Google that. I want to focus, though, on what is not in the definition of T-visa, and not in the definition really of trafficking at all. There's no requirement of movement. Trafficking makes us think of traffic, right? There's no requirement that the child be moved across states or be moved across countries. There's no requirement the child was trafficked into the United States. All of the trafficking could occur once they're already here. There is absolutely no requirement that the trafficker is a stranger. And more often than not, in the cases that I've worked on, the trafficker has been the sponsor or the child's caretaker, a member of the child's family. It can be a stranger, but it certainly doesn't have to be. There is no requirement that law enforcement is investigating or pursuing charges, and there is no requirement for how long ago the trafficking occurred or how long it lasted. I've included here all these slides on physical presence, but Alexa's going to cover those more in depth. Suffice it to say for now, physical presence is why a survivor is still here because of the victimization, why they're in the United States because of the victimization. It does not require that they are physically present because they were trafficked into the United States. And I think, Alexa, you're covering some of the helpful evidence too. So we'll skip forward to reporting to law enforcement. Applicants under 18 and those who are unable to cooperate due to physical or psychological trauma are exempt from reporting to law enforcement. So that's where you want to start on these cases. You are not required, your client is not required to report to law enforcement, but there are some really good reasons to report if your client is willing. That includes, of course, because we don't want other children to be trafficked, but it also includes benefits to your client, including showing physical presence and also changing your adjustment of status timeline in the future. There is no certification requirement like you would find for a U visa. You can request certification from law enforcement, but it's not a requirement of the T visa. And pieces of proof for reporting to law enforcement, you don't necessarily need a like a formal document or a criminal record. You can show through attorney emails or an affidavit from the attorney that your client has reported. And I've listed out some extreme hardship factors here. The focus for you when you're building your case is that you want to look at what is particular to your client. And the most compelling facts are going to be anything around future trafficking, victimization, for your client. That could be the likelihood that the trafficker would retaliate, and it could be also the likelihood of re-victimization. The advice that I've received on these extreme hardship factors is that the USCIS does not want a full asylum type country conditions packet. They want maybe one or two articles that are very specific to the situation of your client, the Department of State report. Common and admissibility issues are in here for your future reference, as is how to prepare a T visa, the forms you need, what a cover letter should include, supporting documents. These are all tools for you all to reference back to, but I'm not going to read slides to you today because we've got an hour and I've got to get a move on. So Alexa's got some time. All right, so identifying, screening, and building a case for labor trafficking. This part of the presentation is really based in the New York Times articles that came out about labor abuses in the United States and sort of what those made me think of in terms of our clients and building these T visa cases. And of course, I have lawnmowers out of my home office. Are you all able to hear me okay? All right. Glad I'm on headphones. Cool. I have included here a link embedded to CAST, which is also referenced as the end under resources. They're the gurus on trafficking, and they have a list of intake interview questions that is really broad, and it covers all kinds of different trafficking. So we're focusing in today on labor trafficking, but it's a great place to start building your own internal agency intake for how to screen and follow up on trafficking cases. I want to focus instead on our work with kids and how to look for trafficking flags when you're doing screening and intake. What you're looking for is a difference in power, and what that looks like to kids can be intimidation, adult privileges, financial dependency on the person. This is the person who is in charge with meeting their basic needs. They are the legal authority over the child, and it's when you see a power imbalance, what that looks like is emotional abuse, insults, threats, gaslighting. Those are the dynamics that you're looking for in the relationship between the child and a trafficker. You're also looking for a controlling relationship, controlling documents, controlling access to their immigration attorney, controlling their ability to cash their own checks or use the money that they are earning. It also often involves isolation, the child's access to other protective adults like their parents or maybe their caretaker in home country, teachers, guidance counselors, their immigration attorney. It looks like controlling access to their phone, controlling unsupervised interaction with their protective people. There's also a really common aspect in these cases of use of the legal system, the weaponization of the justice system against the child. And that looks like in these cases, threats to call ORR or the caseworker or the shelter to give them back to the shelter, threats to tell the judge that they're not behaving. And it also can look like not taking them to appointments, not taking them to see their attorney, or not paying their attorney if it's a private attorney. Also using institutions like the school, making allegations maybe that someone's a runaway when really it's a power play. It also often looks, especially when it's family, like love. It's the emotional harm of withholding paternal love. That looks like in our clients feeling unwanted, shaming between the caretaker and the child, that they're treated differently than other kids in the home, particularly the kids that were born here, or maybe it's a non-parent caretaker and they're treating their own children differently than the kids that they're sponsored. And then I want to highlight throughout this next little piece of the presentation what the cultural expectations are on our clients of deference to adults, what acceptable labor practices look like in the child's own culture, and the ways that kids accept physical discipline that are not in line with the legal expectations of a caretaker in the United States. This list comes from OTIP, and it's flags for physical health, behavioral health, and social environmental health for what you might see in clients you've been working with for a while. And so again, this is just here as a reference. All right, so back in February of 2023, the New York Times issued this expose of exploitation of kids from other countries, immigrant kids who are working in the United States. And my first thought was, how many kids, particularly when I did detention work, would say, I came here to work? And what does that work end up looking like? And is it necessarily exploitation? Is it necessarily trafficking? And that plays back into the cultural expectations for what is expected of a child in supporting their own family, and then, you know, what it means to all of us, right? Even generationally, what expectations were of us to work when we were kids, and is work for a teenager always bad? And then the flip side is, okay, well, T visas are available, and this is a way that we should be advocating for our clients if they're eligible. And a lot of it is about perception of these labor circumstances. And I think the New York Times did a really admirable job of explaining the complexities of child labor, and also explaining how many of the work sites here in the United States are abusive and have labor practices that are really unacceptable in modern times. In approaching these labor trafficking cases, particularly what we're talking about right now in this work outside of the home, but in all forms of trafficking, I want to encourage you again to use the same open-minded, zealous, boundary-pushing advocacy approach that we do with asylum and that we do with SIJ, and consider your child, your client as a child, your client as a part of these power dynamics that that are covered in the prior slides. Okay, so in the New York Times article, one of the kids that stood out to me as an example is a young man named Neri Kutsal. So I'm just going to read through this quickly. Neri Kutsal was 13 when he met his sponsor over Facebook Messenger. Ding, 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 flag anytime you see social media, right? That's an automatic flag for a form of trafficking. Once Neri arrived in Florida, he discovered that he owed more than $4,000, and he had to find his own place to live. His sponsor sent him threatening text messages and kept a running list of new debts: $140 for filling out the ORR paperwork, $240 for clothes, $45 for dinner. Threats like, "Don't mess with me, you don't mean anything to me." Neri began working until 3 a.m. most nights at a Mexican restaurant to make the payments. He said I would be able to go to school and he would take care of me, but it was all lies. Is this trafficking? Absolutely. Neri's sponsor was convicted of trafficking, according to the New York Times article. He was not fulfilling the obligations of a sponsor to provide for the child's basic needs. He was threatening the child. The child was compelled to work. The child had different expectations of coming and being able to go to school, and when it was instead made to work as a child for his sponsor. This is a pretty clear-cut case, and I wanted to start with this because you can see maybe what you might have seen in detention as flags. Facebook Messenger, you met your sponsor through Facebook Messenger, that's gonna, set off some bells. And then what you would see if you were the attorney on follow-up on after this case was referred out, and you start to hear, oh, you're not living with the sponsor anymore, you're working, what are the conditions of work? And we're going to go over some follow-up questions to bring out the rest of these facts. But this is very definitely a labor trafficking case, and I hope that Neri had an immigration attorney who was helping him out. The other case that's wound throughout the New York Times article is the story of Carolina, and this is much less clear. They give some really compelling facts about how she came to the United States to live with a relative she did not know, how the work was dangerous, and how the place that she was working was full of underage workers, late hours, hazardous machinery, violation of child labor laws, and they really compellingly spoke about how Carolina felt about her work and how it physically was affecting her to do this work. They also talked about how she was didn't really understand what she was coming into, how she felt the requirement to support her family, that her family was living off of remittances. How often have we heard this story, right? That we have a client who is working because they feel a deep and compelling need to support family in home country that are counting on them, that put money into them coming to the United States to be able to support their family. And the article talks about how it affected Carolina as a child, how she came to the border already small and exhausted and not in good health, how the sponsor who took her in was also struggling, how child labor was the norm, and how her life looks now, what she expected when she was coming and considered her life in the United States would look like, and how it wasn't the way that she imagined it would be. So Carolina, I think, is a much more typical example of the kinds of cases that we see, and it should set off alarm bells for you of labor trafficking. The first piece, though, is, does it make a difference if the child feels it's her responsibility to contribute? Yes and no, right? Like, of course, it makes a difference to the child. It makes a difference to your client, the person that you're listening to, that it's her responsibility. It's causing her stress, and it is making her see her own work differently. And that is all important. But does it make a difference for what trafficking is defined as under the law? No, it doesn't. It can play into their expectations of work, but it is not a requirement of a T visa that a child be working untethered to their own desires. Does it make a difference if the child worked in home country? Again, yes, it makes a difference to your client, to what they're used to, but it doesn't necessarily make a difference to a T visa case, and it may also mean that they're OTIP eligible whether they were trafficked in the United States or not. So the important piece of these cultural differences and the bouncing back and forth that I find myself doing on these cases all lands on, what does your client want? Does your client want to remain in the United States and have a visa to stay here? Start from there. If your client does not want to be here, that leads you to a different set of follow-up questions. If your client wants to be in the United States, the next step is explaining to them, look, there is this form of relief, and this is what it means. These are the legal definitions in the United States, and this is where this can take you. And then it's your client's decision. So these are the screening questions to get there, but that's what the loop that I always take myself on when a client says, I came here because I wanted to work, or I need to be supporting my family, is, okay, got it. Now, this is the situation I'm seeing under the laws here. This is where it can take you. Do you want to go there? All right, follow-up questions here. If I was doing intake with Carolina, these are some of the things I would want to make sure and know about her work situation and her life, to try and figure out what exactly does the work look like, who's getting money, is there a violation of the sponsor agreement and what's happening here, and what does your life look like? Are you able to leave this situation if you wanted to, and do you have a choice? So those are some follow-up questions for you all to incorporate. This is also from the New York Times article, and I thought it was really insightful about the sponsor. Many sponsors see themselves as benevolent, doing a friend or a neighbor a favor by agreeing or helping a child get out of a government shelter, even if they have no intention in the future of offering any support. Children often understand they'll have to work, but they don't grasp the unrelenting grind that awaits them. This is really the heart of a labor trafficking case with a sponsor. And I would encourage you to look at what the sponsors are signing on to in the OR sponsor handbook. It's linked here because it's constantly changing, but they are signing on to provision of basic needs. They're signing a document that says, you may never threaten or harm the child in your care, including withholding food or water as a form of punishment. And, and importantly to these cases, children may not be forced to work. They're signing on to providing medical care. They're signing on to providing food and clothing and making sure that kids go to school, and all of that is important. I often cite to it in my T-Visa cover letters when it has not been fulfilled. The New York Times also highlighted child labor laws, and I've cited here for you, you want to look to both your federal and state child labor laws to see if there's been a violation there. This quick infographic tells you about how those labor laws change by age. Texas does not have a whole lot of additional protections for young people working, so they're very similar to the floor set by the federal law. Kids under 14 are basically not supposed to be working in any sort of formal environment. Kids 14 to 15, there's an hour requirement that they should still be going to school, that they can't work more than a certain number of hours during school days, and that work hours need to be from 7 a.m. to 7 p.m. There's requirements about what kinds of work are allowable for kids 14 to 15. And then 16 and 17, it flips to any non-hazardous position. So look at your child labor laws, and that'll also tell you where you should be reporting. Department of Labor, Homeland Security Investigations has also been a really great resource, and then you can look to your local law enforcement. I am not covering labor trafficking inside of the home, but I would encourage you to look at the other presentation that Sila has up from a couple years ago where I discussed that more in depth. And I just want to flag for you this new form of labor trafficking decoy cases that I have recently seen an influx of where children are used to cross the border to create a false family unit. These may be trafficking cases, and feel free to contact me about them because I am knee deep in this right now. All right, and I'm turning it over to you, Alexa.
Thank you so much, Lauren. Hi, everyone. I'm Alexa Sandukis. As has been said, I work at GURP and I manage our Immigrant Children and Youth program. And I'm here to talk to you today about filing T visas for children and youth based on trafficking in home country and or transit to the United States. So like Lauren said, our goal today is to inspire you to be creative, be zealous in your advocacy, and file applications and screen for these situations because they are successful. I'm here to tell you that, and I'm here to provide some specific examples of applications I have filed that have been granted by USCIS. And I will say at the beginning, this is not the traditional use of the T visa. Arguably, it was envisioned for trafficking that occurs in the United States, where the survivor is here and helping law enforcement bring the traffickers to justice. And I did consult many people who are considered experts in the field and have a lot of experience with survivor visas when I first began filing these applications, and I was told by many that they were not going to succeed. And I am by no means an expert in T visas. I only began filing them in 2019. So if I can win these, you can win these cases. So let me first talk about why you might consider pursuing a T visa in these circumstances, which I encourage you to do. So initially, a big motivator for me was the fact that 5,000 principal T visas are allotted every fiscal year, and they are never granted. It's not even close. Based on the data I could find between fiscal years 08 and 2021, less than 1,500 have ever been granted in a given fiscal year. And in fact, less than 3,000 have even been filed. So there are a lot of visas being left on the table. It also appears that youth are underrepresented in these statistics because, again, based on this USCIS fact sheet data that I've linked in the slide, only 7% of principal T non-immigrants between 08 and 2021 were under 18. And based on my experience, it seems like there may be many more children and youth who are survivors of trafficking who are simply not filing T visa applications. Another reason to consider T visas, a lot of these survivors also qualify for asylum since they've experienced past harm in their home country and they have a fear of returning based on that past harm. So you may be filing both an asylum application and a T visa application. And I certainly would encourage you to file both if your client qualifies for both. But the T visa has some benefits that are even better than asylum, particularly for children and youth. So one of them is derivative relief. Particularly parents and siblings can get status pretty quickly if a T visa is granted for someone when they file it before they turn 21. The process itself is also can be faster and easier. So unlike in the asylum, in the affirmative asylum context, there's no interview for a T visa. It's typically all done through mailings. Current processing time for T visas at the Vermont Service Center, which is the VSC, is 17.5 months. I have seen quicker in the past, and I do think that processing time varies. But even so, it's way faster than most affirmative asylum cases are heard, particularly right now. And another advantage over asylum is that the T visa does not have a 1-year filing deadline. In fact, it has no filing deadline whatsoever. Fourth reason that you might consider a T visa is because it is a discretionary form of relief. So a USCIS adjudicator is reviewing all your evidence and they have a lot of discretion to grant or deny a case. So when you have a particularly sympathetic client, which is often the case for a minor child who is a survivor of this type of harm, you may have a higher chance of getting it granted. You just need to marshal all your positive equities. And yes, there may be a request for evidence or an RFE on these types of cases, but you can overcome it. Some other reasons to consider a T visa, going back to the definitions that Lauren covered, as we mentioned, minor children are exempt from certain requirements for the T visa, the most significant of which is the law enforcement cooperation and reporting. And this does apply even if you file the T visa after you turn 18, as long as at least one act of trafficking occurred prior to turning 18. And again, in this context, there are other exceptions may apply, such as trauma, suffering from trauma, such as PTSD. And then another factor we use in these types of cases also can be reporting to CBP. For example, when you come across the border and you tell CBP what happened to you and they simply don't investigate, you've at least done your duty in reporting it. And a lot of kids have also, who, if they enter as unaccompanied children and are formally designated and sent to the Office of Refugee Resettlement Shelters, they often tell their counselors, and there's a report of that, and the counselor sometimes also gets them an OTIP letter, which has a lot of benefits in this situation. The other exemption for minor children, looking at kind of the regulations and the policy, is that when you're talking about sex trafficking, they don't have to show the means, which is force, fraud, or coercion. And that is because USCIS states that children under 18 cannot consent to sex acts. It differs in state law, but we're talking about federal immigration law, and that's the view that USCIS has taken. So when you're talking about sex trafficking of a minor child, you only have to show the process and the end. Finally, T visas for minor children and youth, and I'm defining youth typically as between 18 and 21. Age is a traditional factor that USCIS adjudicators consider when they are thinking about the extreme hardship element. That's the element that goes to their inability to be returned to home country. And so officers are looking at the age of the applicant, both at the time of their entry to the United States and at the time of their T visa application. So this can definitely work in your favor if you're filing for a minor child or someone who was trafficked as a minor child. So now that we've encouraged you to screen for and file these T visa applications, you may be wondering, well, how do they qualify? So let's assume that they meet the definition of human trafficking that Lauren already covered. Typically, your biggest challenge on these types of cases is physical presence. And as Lauren mentioned, there are many ways to show physical presence. If the trafficking occurs in the United States, that's an obvious showing a physical presence. Or if you're liberated by law enforcement in the United States, that's another way to prove physical presence. When you're talking about trafficking that occurred outside the United States, the USCIS policy manual has some specific definitions and examples that inform how you can prove to the adjudicator that you meet this element. So the most common way to show physical presence is that the applicants were subjected to a severe form of trafficking in persons at some point in the past, wherever it may have occurred, and their continuing presence in the United States is directly related to that original trafficking. So in other words, you're looking to establish a direct relationship between the ongoing presence and the original trafficking. Now, USCIS, again, the policy manual has specific factors that their adjudicators can consider when they are determining whether an applicant meets the physical presence element. And I've listed them here verbatim. I'll run through some of them and kind of emphasize how you can show these. So the first is ongoing psychological and or physical trauma suffered as a result of the trafficking or the victimization. Those are USCIS's words. A lot of times we see this in the form of post-traumatic stress disorder, anxiety disorder, depression. Sometimes it can involve suicidal ideation, past or present, and or self-harm. This is typically going to come into play with respect to a counseling letter, a letter from a counselor, and or a psychological evaluation if you choose to file one of those. And again, health diagnoses stemming from the victimization, I've kind of combined that with the first factor, but that's again going to come from your psychologist evaluation. Another important factor in this context is the ability to access legal and therapeutic services as a tool for rehabilitation in the United States or in the home country, and whether the applicant is currently or has recently accessed trafficking-related services and benefits. So this is going to be a big benefit if you have an OTIP letter, because the OTIP letter enables you to access these services for free and connects you with someone who can provide those services. So a lot of times we are showing that the applicant is currently receiving social services assistance, free legal representation, counseling, any sort of victim service that is available to them in the United States that they would likely be unable to access in their home country. Another factor with respect to physical presence is any current efforts the applicant is undertaking to rehabilitate, stabilize, and acclimate to society, including self-identification as a victim or survivor. So the self-identification part is not required, but it can come into play in the applicant's declaration, as well as a letter of support, for example, from a social services coordinator who's assisting them, or even their attorney. It could go into their cover letter. Another factor, the level of control or fear the trafficker still exerts over the victim, including if this manifests as continued fear of law enforcement or immigration authorities, and fear of retaliation from the trafficker in the home country. Two more factors, current cooperation with law enforcement, that is optional, as well as any other activities the applicant has undertaken to deal with the consequences of having been trafficked. Now, USCIS also provides some examples of when you're likely not going to be able to show ongoing presence, and that is where there's repeated travel outside the US since the trafficking, so long as these departures do not stem from the trafficking. So for example, that would probably look like multiple vacations abroad, as long as it doesn't have anything to do with their trafficking. Two other instances where they might be inclined to say that there is no ongoing presence that's directly related to the original trafficking is when an applicant does not have continued ties to the United States or has established an intent to abandon life in the United States. I see this as potentially renouncing citizenship, spending a lot of time outside the US, that kind of thing. And USCIS also has one note where you can still establish ongoing presence where you have reached certain milestones or had life developments following the trafficking. So they do want you to be rehabilitated, and they are saying if you have achieved certain things in your life since the trafficking, that does not disqualify you from getting a T visa. The examples they give are getting a new job, not the trafficking job, having children, getting married, and managing mental health diagnoses. So showing some sort of progress since your trafficking. And if this has occurred, you're just going to want to explain the impact of the trauma that you continue to experience as a result of the trafficking. So you can have both things. A couple other considerations for the physical presence element before I talk about some of the evidence you can use. As I mentioned, there is no filing deadline. USCIS explicitly states that you're not required to file the application within a certain amount of time after the original trafficking. You also are not required to be in an ongoing trafficking situation, be in continuous contact with the trafficker, interact with the trafficker, or be under the control of the trafficker. So once you have escaped from the trafficking situation, no matter the time lapse, you can still apply for the T visa, so as long as you prove all of the elements. And USCIS also endeavors to consider all the evidence that you submit using a victim-centered approach. So some of the suggested evidence that you can file in these cases, I tend to do a more detailed cover letter because I know that these are requiring some zealous advocacy, and it might not be the type of T visa application that these USCIS officers are used to seeing. So I like to lay out each element, explain how my client has met those elements, and I point to specific evidence that we are filing. I usually also include, or I always also include, a counseling letter or a psychological evaluation at the outset. So I will say that CAS advises that you may want to wait to submit a psychological evaluation until if and when you get a request for evidence. And they say that's because if you get an RFE, you can tailor your psych eval to the issues that have been raised by the adjudicator in the RFE. In these cases, in these applications that I'm filing, I know that physical presence is going to be a potential issue the adjudicator is looking at. So I do tend to file my psych evals early on and make sure that my counselors have spoken to that element in a great detail in their evaluation. But you could potentially also just file a letter saying that the client is accessing counseling and potentially just include a short synopsis of the reasons why. Another thing that I feel is a must piece of evidence to file in these cases is a support letter from a social worker or social services coordinator that's assisting your client in accessing social services, whether it be through the OTIP letter or independently. This is a really good way to show that they are in the United States directly related to the original trafficking because they're accessing crucial services that they cannot get in their home country. The last must piece of evidence to file is the declaration. Now, this is true for any and all T visa, and we do know for a fact that USCIS relies heavily on the declaration when they're making their decisions. So the other evidence I typically file, country conditions reports and news articles. Like Lauren said, you probably just want to focus on the strongest pieces of evidence. It's not like an asylum case where you're filing tons and tons of reports and articles, but certain key reports can be really helpful to prove your case. Expert affidavits you may consider filing. For example, I've done some expert affidavits available through CGRS on the rights of children in various countries, which goes to the extreme hardship element and their ability to access social services in that country. ORR records can also be useful. I sometimes use them to corroborate my client's story when they've reported things to their counselor. And especially if there are significant incident reports or SIRs, you can use those as corroboration. And then, of course, the OTIP letter is going to be very important if the trafficking occurred outside the US because it shows that they qualify for services in the US. All right, so now let's talk about some specific examples. And these are all cases that I or my colleagues at GURP have filed. So, and I'm going to run through them one by one in more detail. But the first example I want to talk about is the so-called gang girlfriend situation. And so I had two clients, they were sisters. They were kidnapped and held hostage by a gang in El Salvador, and they were made to be so-called girlfriends. They were, of course, being trafficked. They were not willing girlfriends. So this, I want to walk through kind of like the timing, the location, how we define the trafficking, and then a little bit about the adjudication by USCIS. So for these, we filed their T visa applications before they turned 18, and the trafficking also occurred completely before they turned 18. They were trafficked in their home country solely, and their actions involved are recruitment, transportation, and harboring. So this was the gang. They recruited, they kidnapped them, and then they harbored them in a gang safe house. They used threats to themselves and their family members, and they displayed weapons as a show of force to get them to come with them. And they also used force with one of the sisters. Means in this case, we did not have to show means because this is a commercial sex or a sex trafficking case. And so they cannot consent to sex as minor children. But I do mention, of course, there was force and coercion. And then the purpose was commercial sexual acts. So essentially they were forced to have sex in exchange for food, shelter, and their lives. In this case, some other considerations involved. It was a gang. It was a very powerful gang. So when you're talking about their inability to return to the country or the home country's unwillingness or unable to protect them if they have to return, it was pretty strong because everyone knows that the government is not capable of responding to the gang. I will say, you know, depending on who you ask, this may have changed recently, but we're talking about these cases were filed in 2020. And then these girls were also part of other vulnerable groups, and this had to do with gender-based violence as well as the lack of parental protection. So these are facts that I've definitely brought out in the evidence we filed. These were both granted by USCIS, as I mentioned. They were both filed in 2020. One was filed a little bit earlier, before the older sister's 18th birthday. They did both get RFEs, and I'm going to show you a little more about the RFE on the next couple slides. And then they were both approved last year. You'll notice one was approved in 26 months, one was approved in 14 months. I suspect that's an arbitrary difference based on which officer had the file. And the one that took longer to adjudicate actually suffered further victimization in transit to the United States. So another sympathetic factor that did not result in a quicker adjudication. So on the next slide, I have an example from the RFE that we received for one of the sisters. And like I mentioned, it quotes heavily from the declaration. So I can tell they reviewed the declaration, yay. So in the RFE, it talks about essentially, it admits they were trafficked in home country. You and your sister were kidnapped and harbored by suspected MS-13 gang members while you were living in El Salvador. Gang members brought you to her house. You were locked in a room, raped. At one point, you were also forced to take drugs. You were harbored by the men in this house from February to November 2018. Eventually, the police came to the house and everyone fled, including you and your sister. And then it details the fleeing itself. So they fled to their grandmother's house, then to their aunt's house, called their mom, who was in the United States, and the mom agreed that you should come to the United States. So she did. And so USCIS stated that they acknowledge victimization by the gang members, but it did not appear you continued to be subjected to trafficking after arriving in the United States. Therefore, you cannot be considered physically present in the United States on account of such trafficking. So I do believe this was a misapplication of the law and the policy at the time. There is no requirement that you continue to be subjected to trafficking after arriving in the United States. Rather, as we've discussed, you just need to show that your continuing presence in the United States is directly related to the original trafficking, wherever it may have occurred. So in this case, we argued that the trafficking occurred outside of the United States, but they escaped, fled straight to the United States, and here they have remained since that time, where they can receive services and counseling to deal with the trauma of that ordeal. So on the next slide, I provide you a little bit about my RFE response in this case. Next slide, please. Perfect. So with our RFE responses, we're typically directing USCIS's attention to previously filed evidence and kind of highlighting some parts of that evidence that support the claim we've made. And we also typically file additional evidence, although I do think that it could be optional. But I think it's the strongest showing to do both. So in this case, we did include a supplemental declaration of the applicant. There had been some passage of time, some new developments, and we wanted to highlight that, as well as the continuing trauma and fear that these clients were experiencing. We also included another support letter from a social worker that had that was helping them access social services. This is simply because I had changed organizations in the interim, and I took the clients with me pro bono, and I had to assign them to a new social worker. So we were trying to show that they were still receiving crucial social services and counseling. If that didn't happen in your case, of course, you could consider including an updated letter from the same person on their case, providing social services. And then we also included additional country conditions evidence. In this case, the State Department's Trafficking in Persons report for El Salvador had not been filed in the first place, so we decided to file it. I believe this was one of my first T visas I filed, so currently I would have filed that with the original filing. And then the other part of our RFE responses, we kind of included a letter brief, and we focused on 4 factors. At the time, the USCIS policy manual had just been updated between the time we filed this and the time we got the RFE. So we pointed to that change because the revisions were very favorable. And so these are the 4 factors we focus on: the ongoing trauma, the health diagnoses, the social and legal services, and the control and fear. And so we pointed to specific pieces of evidence. Next slide. So I know that I'm running out of time now. So I'm just going to briefly go through the last examples I provided, and you can check out the PowerPoint that's posted on the CELA website. This had to do with migrant protection protocols, MPP. That was the Remain in Mexico policy during the Trump administration. So I had a client who entered with his dad, was placed in MPP, and was kidnapped and forced to work for the cartel. He eventually escaped and came to the United States as an unaccompanied minor, and we ended up filing his TVisa application after he had already turned 18. So for him, we used the trauma exception to the reporting requirement, as well as the fact that he was trafficked while a minor child. And that was approved in 10 months without RFE. I'm not sure why it was so quickly. And I also included a mountain of evidence documenting the harm suffered by MPP to sort of highlight that the policy of MPP was part of the problem. Next slide. So this is just kind of an excerpt from the table of contents. This is not your typical evidentiary filing. It was a lot. I decided to go with the paper them strategy. But you'll notice at the bottom, I do provide an annotated table of contents because, like in the asylum context, I'm assuming the adjudicator is not going to review every single piece of evidence I file. So I annotate the most important parts, hoping they'll at least review my table of contents. Next slide. This case I highlight because I was honestly surprised when it was granted, but I employed an argument by Tom Borman, who's a very well-known expert witness in the asylum context, that the forced coercion into gang service by children and youth in home country is a form of trafficking in and of itself. And this was RFE'd, but then it was granted pretty quickly. And there was additional victimization en route to the United States that I argued was a form of sex trafficking. And so I can't be sure on what ground USCIS granted this, but I do believe that both pieces of the story were compelling together. On the next slide, I kind of highlighted a little bit from my cover letter where I cited this article, just to show you that, this is a very common fact pattern we encounter with children and youth clients, particularly from Central American countries, and it can be seen as a form of trafficking. Example 4 on the next slide was a very unique case that I probably won't go into. It had to do with a kid who came with a student visa, and CBP revoked his visa and detained him. And I felt that an injustice had occurred to my client. CBP had said he may be a suspected victim of trafficking, but there was no investigation and the alleged trafficker was never brought to justice. So it seemed like potentially CBP had made an error, but they revoked his visa and detained him and kind of put his life in disarray. So I filed this application and I argued really hard with a very long letter brief and various pieces of evidence. And ultimately they agreed that he had been attempted trafficked. And finally, example 5 is a labor trafficking case. It was a female client of ours who was pregnant. She was used in home country as a drug mule because of her age and pregnancy status. And so this was a labor trafficking case, and that is still pending. But I do know that there were other children working for she called them sicarios. So this may be something you encounter as well. Again, this is our takeaway. USCIS is granting these, so you should please screen for them, apply for them. They can win. And now we've included some additional resources, as well as our contact information if you want to get in touch and chat about any cases you're seeing and want to file. I see there are some questions.
So I've tried to answer them in the chat. I think we have a few that just came back through. But since we're out of time, I would encourage you all to contact us by email with any additional questions. And thank you to Sila for this opportunity to convince you all that TVisa is the next case you should be filing.
Exactly.